if there's money out there and if interest rates are low and money's cheap, then people are going to invest.
The Weekly Friedman, your source for the most essential information in the default industry. With your host, Adam Friedman.
It's no secret that business purpose loans are a growing asset class across the country. Today, we're going to discuss some evolving disclosure laws specifically across the East Coast states. To help me work through this topic, I'm joined by Director of Client Relations, Michael Chisholm. Mike, how's it going today?
Pretty good.
It's been a hot topic, right? Business purpose lending has been growing exponentially over the last couple of years. Do you see this as something where states are uniform in what they're creating? How do you feel like this is going?
I think that there's two parts here. One is, I think we're seeing an increased default rate in BPLs across at least our footprint, I'm sure across the country. BPLs in the default space have definitely become more of a highlighted area. And I think that naturally draws the attention of some state legislatures. So yeah, we see states that are going to tend to have more involvement in their default laws, such as New York, New Jersey, definitely now starting to evaluate, whether it's through court cases or through the legislature, evaluate areas of concern in BPLs.
You know, it's interesting when you think about states creating disclosure laws around business purpose lending, because the justification for disclosure laws throughout normal resi lending is protecting borrowers. When we're talking about business purpose lending, it's a different purpose. And presumably, when a borrower is an LLC that is purchasing a property and needs a loan to accommodate the fix and flip and all the work that they're doing, not only are they presumed to be a more educated buyer, but instead of them losing their house because they didn't understand what they were borrowing, their home, they're losing out on an investment. So do you feel like these disclosures are as warranted?
Yeah, I mean, I think that just anecdotally, you would think that these are more savvy borrowers. And the reality is, I think we see a lot of defendants who were jumping into a hot market in COVID or pre-COVID, trying to buy a handful of properties, 1 to 4 units. And really, that might have been one of 2 or 3 assets, right? So maybe it's a reaction to the fact that you are, through the BPL, also impacting the rental market. And so I think maybe the state legislators like New York, they're looking at this perhaps through the lens of, if you don't have better disclosure to these LLCs who are purchasing the loans and understand the debt in the same way you would to a residential borrower, you're then going to lead to people who are losing properties that are housing renters. It seems like when they're trying to converge the two, resi lending and BPL lending, and we're not talking about commercial, we're talking about BPL for generally the purpose of 1 to 4 units, right? So I think that's kind of the mindset, is that they're looking at this as like housing in general.
Is there anything really weird and unique? Or are we basically looking at a handful of states imposing disclosures that are somewhat similar to residential consumer style disclosures?
So in New York, you have the Department of Financial Services, which made a rule that was effective, in 2023, that required more consumer disclosures, more consumer style disclosures. You have Maryland passing the Small Business Truth in Lending Act. Well, the Senate passed it, it's awaiting House action. And you have New Jersey, which has a Senate bill that's still pending, but aiming to align with other states' disclosure framework. So it's clearly a disclosure thing on the terms of the loan and on ensuring that there's adequate maybe understanding or knowledge of people getting into these BPL loans of what the outlook looks like over time, as these loans do have different terms, different writers, and different requirements for maintaining that loan.
What I'm trying to wrap my head around here is the type of borrower and the evaluation they should be going through. So a consumer purchasing a home, they're evaluating like, what's my monthly payment going to be and can I afford it? It's a relatively simple analysis, assuming you know the number and you could budget yourself. And it can be very complex when you have non-traditional loans, like an IO loan or variable rate loans. I think the disclosures are really helpful because it can assist the borrower in managing the long-term plan of how the payments are going to work, but also understand how different fees tie in. When you think about a business borrower for an investment purpose, the whole reason for getting this loan is to make money. It's somewhat incumbent upon the borrower to do the math and make sure the investment they're doing is affordable and profitable. In imposing these types of rules, you're really holding the borrower's hand a little bit. And it's interesting to see a government or a state hold a business's hand on a loan that they're borrowing in the same way they would try to do it for a homeowner.
I think it's interesting when you look at the buying rates during COVID of properties as investments, right? And third-party sale success rates or third-party auction bidders winning at such a high rate In some states, it's 60% at foreclosure sale. And I think that you see now, just this growth in not like apartment rentals, but home rentals. And in some communities, I mean, it's double-digit percentages of neighborhoods. I think that's got to factor into these kinds of decisions. We're also seeing, though, reinforcement of protections for lenders. So we have case law in New York coming out that just, again, reaffirms the right to deficiency judgments when you file the motion properly and timely. And that's another thing that's happening in this. You see an increase in interest in deficiency judgments as lenders are putting more money on the line for people who presumably should make a return, with the rental market. And if you're a poor business person, if the economy in your area doesn't support the cost to rent that home and make the money you need to pay the mortgage, but you have other assets, we're going to come for those other assets. So I think a lot of this ties in together of not just protecting the borrower, but protecting the lender by making clarity, and nobody can really argue you didn't know or that you didn't put other assets on the line. It's just a very complex part of the market right now.
Do you think this will matter? Like, do you think increasing disclosures to business-focused buyers, companies that are buying to flip, do you think it'll matter?
I think from our perspective, disclosure just means there's less argument in the courtroom. Everything was upfront. Everything was clear. If there's money out there and if interest rates are low and money's cheap, then people are going to invest. And I don't think that it creates an undue burden on the lender or the borrower. Maybe in that sense, it won't matter. I think that it's clear that individual investors are trying to find ways to skirt around issues like deficiency judgments or going to court and claiming that they didn't really understand that this was a different type of mortgage than a standard mortgage, when we all know that going through a business purpose mortgage with the additional addendums and riders, it's pretty clear it's a different type of beast. I think maybe this just creates more clarity for everybody involved.
One thing I would love to hear, if anybody's watching this, who is a business purpose borrower, it would be interesting to hear your feedback on this. Do you feel like you've had certain situations where you borrowed money and did not understand the terms? Maybe they were overly confusing or almost like hidden within the docs, or just your perspective as to whether seeing these disclosures would change anything. It may just make it easier to decide between lenders. And I think that's a valid purpose. So I'd be interested to hear from a business purpose borrower or a lender as to their perspective on how this will impact them.
I think it's an interesting ongoing conversation.
Thank you for joining Michael Chisholm and I on the Weekly Friedman, your source for the most essential information in the default industry. Thanks for tuning in and looking forward to seeing you next time.